White-collar crimes are peculiar in nature. They undermine the economy of the country and hence are important. But simultaneously, the problem is riddled with low conviction. If something is as important to the economy of a country as white-collar crime, is it not necessary for the prosecution to be more adept and ensure convictions? Or is the problem somewhere else, of unnecessary prosecutions and a harassment of honest businesses? This is the discussion that we will have today. So with that, we have Malak Bhatt, who is going to be arguing for the accused and say that the system is geared against the accused and the ED often abuses its powers. On the other hand, we have Neeha Nagpal, who will say that all these white-collar crimes are imperative to ensure integrity within the business community, that the government is doing its best to ensure stability in the economy. Where does the truth lie? That is something we will find out in the course of this discussion.
Thanks, Saurabh, for the very nice introduction to this debate. And in fact, this debate has been spanning over a good period of the last 5-6 years, where we've seen a lot of action by the agencies, be it CBI, be it ED or the SFIO. And large part of the issues which we always face is at the systemic problem on how these investigations have spanned out. A large panic happened around 2018-19 when the entire bank fraud system was brought in and banks started declaring companies as fraud, or they started pointing out issues of siphoning, etc. But what we've seen is that typically it ends up being more of a panic button which is struck just to protect the skin of either a public servant or the system. Are we then protecting the rights of the accused as would be protected in the normal criminal jurisprudence? The straightjacket answer, at least which I feel, is no. Because the law which applies to a criminal who is facing any other criminal prosecution should ideally be the same for someone who is facing a white-collar crime prosecution. However, we see multiple raids, we see n number of investigations being opened up against the same person, the same entity. You have a general perception that if there is a bank default, it will automatically become a fraudulent exercise. And therefore, there is always an impression created of guilt before the person steps into the prosecution or before he goes into the investigation. So I feel it's, first of all, at the very outset, a systemic failure where the rights of the accused are, from the very start of the investigation, jeopardized in the manner in which the investigation takes place. You have issues of bail, for example. You have large number of Supreme Court judges time and again saying that the Supreme Court has become a bail court. Why so? Because every corporate fraud matter where someone gets arrested gets taken into custody, and he has to spend a large part of his, I would say, litigation expenses which he has saved for himself going just to secure his liberty, which in an ideal system should not be so. So therefore, are we really protecting the rights of the accused is really the point where the accused really stands at a very different footing from where he should be in an ideal criminal justice system.
Well, thank you for hosting us. It's lovely chat. And so my view from Malak is slightly different, as you would also put that forward. I think that we're today, let's go back to 2014. What got or became the impetus to bring in the insolvency code? It was the staggering amount of bank NPAs. So we're faced with a system today where if you don't tighten the noose, you have borrowers getting away with impunity, and who suffers? The system is suffering. There is a whole catena of Supreme Court judgments, as Malak points out correctly, in bail law to say that bail in economic offences should not be given instantly. And why is that so? Because like in the PMLA, it's a reverse onus clause where Section 24 demands that the person who's accused has to, bring forward the case to defend themselves. So the burden as such on the prosecution is eased to some extent. Why is that so? Because the person doing the transaction has a specific knowledge of it. Coupled with the fact that you have these large-scale borrowings happening, you have large-scale NPAs happening. you have a lot of money being rooted out or related party transactions happening and consequently defaults happening. Who is going to be responsible? Are we bleeding our own system? That is why the government of the day had to come forward with the fraud circular, which is a bit harsh, but sometimes it's only when you really fear and wrap around your knuckles badly is when the system corrects itself. So that's really where I think all of this has come from. Yes, you're right. The conviction rates remain low, but that is not at the level of really the laws put in place or the legal sanctions put in place to correct the system. It's more a thing of general delays in disposal of justice.
See, on the question of conviction rates is something we can discuss maybe in the next segment. The sense I get from both of you is, are financial crimes meant to be pro-citizen or pro-state? And the answer, as so often, lies in the middle. A financial crime is not unlike any other crime. We cannot imagine a society where there is a rape and murder, which is also a undermined society. Similarly, financial crimes also undermine society in a different way. And the way we draw balance in all kinds of crimes is you preserve the innocence and the presumption of innocence of the accused, preserve their liberty and their rights, but simultaneously you do not carry those rights to such an extent that the very enforcement of the law by the state becomes weakened. So the balance that the Constitution has drawn in this case is Article 21 and 22, which is that you have a fundamental right to liberty. When you do certain actions which violate the law, you have certain protections. The job of Parliament and the executive is to enact laws to ensure that wrongdoing does not happen. But in the process of ensuring that wrongdoing doesn't happen and the culprit and the guilty are prosecuted, you don't want to rope in innocent people. You also don't want to do something which will then ensure that the animal spirits of the economy are curtailed. So that is why you have a lot of protections in the law to ensure the fact that you can get bail, that there are statutory protections. In financial crimes, unfortunately, some of those protections have been whittled away, both in law and in practice. But let's just talk of law just now, because that's what we started with. The whittling down and the idea that bail should be more difficult to get in financial crimes does make sense, as Neha said, because it is a person who's actually committed the crime who will know where the money is. That may well make sense, but I cannot imagine a society where it is only financial crimes which will lead to bail being so difficult. Do we want a system where financial fraudsters are kept behind bars, but murderers, rapists, dacoits, they get bail more easily? We don't live in a society where these crimes against the person don't exist. And if society has not fallen down, and it hasn't, by giving bail as a general rule in those cases, is it not time for us to think that if criminal law can normally happen with bail being the rule, why should financial crimes really be that different?
Absolutely. And in fact, since you started with Article 21 and bail, the jurisprudence on bail since time immemorial has been, it is only for two purposes. One, to ensure that the so-called suspected accused does not impede the investigation, and at the same time to secure his presence. If these two objectives are met, especially in financial crimes, is he really someone who will deter the progress of the society if he is granted bail? The answer will obviously be no, because he is not someone who is facing a rape or a murder charge, who ultimately is someone who the society does not want to be present amongst themselves. In fact, it's the other way around. Can the financial crime system be worked out so that if it is suspected that the person has actually pocketed money or has committed a financial crime, should he not be made to undergo a condition to actually retrieve that money? If he is someone who knows where the money today lies, if he is the one who's diverted the money, in fact, the system or the way the mechanism should work is to ensure that he's able to recoup that. Because I understand we are talking about public money here. We are not talking about his own money, which is, sent away at various places. But since banks are involved, financial institutions are involved, we are at some place talking about public money, which is at large. In a scenario like this, to bring out conditions which are harsher than normal criminal law, to say you will have to prove to the extent at the very initiation of the investigation that you have not committed a crime, to say that you will have to spend larger time in jail, whereas in fact with someone like this being out and being able to work out either a settlement with the banks or trying to narrow the gap of the so-called financial fraud may actually work out better for the system. And to that extent, look at the recent example that the Supreme Court has laid down in 𝗃𝗵𝗃𝗁. It's unprecedented, but at the same time you have money coming back into the system, because ultimately if the allegation is to stem true that the victims of this entire exercise were the public institutions, it is they who are actually getting the money back way before time than the prosecution would have spanned over the next 10-15 years. So you're actually getting the time value of money. Secondly, as you said, the prosecution will end up being for a long time, and ultimately the conviction rate being low is actually, in my understanding, a very, very big hint to the systemic failure for two reasons. One, the process itself becomes punishment for an accused like this. And secondly, the fact that the prosecution whittles out over a period of a long time shows that it is not, and in most cases, you don't even end up to the end of the trial. Forget conviction. You're not even seeing cases which are going towards framing of charge or towards leading of evidence. So are you then in the garb of creating this large umbrella of a generic exercise that financial fraud will not be tolerated, nipping people who otherwise were only part of, say, an actual bank loss, which need not translate into a fraud at every point of time, be garnered into this bubble of financial fraud and putting him in the same periphery of being someone who's actually branded a financial fraudster at the very beginning of the prosecution.
So I think Malak covers with a lot of points with a lot of depth. And I think if one looks at it from the other side of the prism, why has bail become so difficult in financial crime cases? I think largely two reasons. One, that there is this apprehension that if you allow the big fish, as they're often called, people with influence, to get bail forthwith, or rather easily, without, in most of these cases, you have the so-called twin conditions. Without those being satisfied, what happens is that they have the power, the wherewithal to influence the pace of the trial, so which is now taking 10 years, could potentially take 15, 18. B, they also have the wherewithal to cover their tracks in a manner of speaking, where, reverse transactions or come up with other structures which could break down the prosecution story. So I think those are the large two parts that sort of make bail in these cases very difficult. Yes, there is a systematic failure which we cannot shy away from, which is the long delay in prosecution meeting its end. That I don't think is just about white-collar crime, or it's all across the board for every kind of crime, or even in civil cases. So that has to be addressed, that has to be divorced from the issue of the delay and low convictions in white-collar crime. The 𝗃𝗵𝗃𝗁 judgment, as the Supreme Court itself said, this cannot be used as precedent, which I think is fairly, otherwise it would open floodgates for everybody. It also is an antithesis to what is the law of the land, the criminal jurisprudence, that the day the offence takes place, that day the offence is complete. You may want to compound it later, because a 420 offence is compoundable with the permission of the court. That's a separate issue altogether. But 𝗃𝗵𝗃𝗁 also, it was not day one that the payment was made. It has gone through a vagary of the judicial system. It has gone through its delays. It has gone through arrests and LOCs. And it has been the criminal system which has compelled this payment. So somewhere it is the legal system which has moved, shaken up people and brought them to come and give the money back.
See, what I'm assessing from the both of you is we have to question what is the purpose of bail, because we're still at the point of bail in the discussion largely. I think on the one hand, you say that bail should be given as a matter of course, because that will enable a business person to come out and maybe achieve recoveries, and that will safeguard the interest. On the other hand, till you have a stick on people's head, which is going by jail, people are not going to volunteer to give the money up. So do you take a carrot approach or do you take a stick approach? And that, I think, is largely the dilemma. And the problem really in all of this is that between the carrot and the stick, we forget that constitutional obligation again of Article 21. The state is not meant to use sticks. The state is not meant to use carrots. The state is supposed to neutrally enforce the law. The problem in a country like ours is that often it is seen that because the conviction is so slow, and if you don't put people behind bars for some time, and eventually they will be acquitted, then there will be no punishment at all. So to stop that perception, that to make sure that some kind of a just desert is given to people, very often judges, maybe in their mind without quite saying so, think that let's give him a dose. Let's keep the person behind bars for a little while. Let them be in for 6 months, 1 year, and then you come back to us if you don't get bail. That is the jurisprudence also of that if the trial doesn't start within a certain period of time, then you come back to us. Till then you stay in jail. So the judges are trying to balance the retribution that society demands for a criminal offense as opposed to the liberties that the Constitution promises. But in doing so, I think the problem is you've thrown the baby out with the bathwater, rather than saying that bail should be used as a substitute for punishment. You have to have systems in place where the punishment itself is expeditious. I mean, there's a lot of research, we can talk about that. But tell me, Malak, why is it that you think that in matters in relation to the enforcement directorate, other financial crimes, there is such a massive delay? Now, I don't think either side can disagree that there are delays. Does the delay lie at the hands of the accused who file multiple applications, or is it because the investigation is not done in a fair, efficient, and a proper manner?
So I'll say it's the latter, and probably we can try and hit the nail on 3 or 4 heads. The first being, if you look at the manner in which an investigation spans across, let's pick up the example of a particular company which has a web of structures, as Neha said. You will see multiple agencies gunning for the same offenses or trying to investigate into the same bucket of transactions that they're looking at from different angles. There is no coordination between them. There is absolute overlap in the way the investigation takes place, and ultimately the investigation is only for the purpose of trying to bring everything within the fold, which may not be the best course of action for any investigation. If let's take the example of a bank fraud, and if you're saying that the money of the bank has been siphoned out, probably the exercise that the predicate agency will do is to actually pinpoint where the offense lies. The ED's role would come in to just secure where the money has actually gone into and to see if that has really caused the taint to be lifted. Today, what you will see is, you will see the CBI looking after, on the registration of a case, you will see the CBI going into the entire affairs of the company to see if that person was really a good or a bad businessman, whether he has taken decisions prudently or not. You will see the ED coming in to bring out every possible transaction which is undergone in the last 7-8 years, to try and first come to a conclusion that yes, there is a preset notion that the money has been diverted, and then try and find faults with everything. The larger systemic problem which I see happening is the idea of a business going wrong is not taken to be something which is plausible. Today, the entire reason why the IBC came in place is that there could have been good businesses but run badly. That underlying notion today is completely forgotten when it comes to the criminal machinery. So you will see, and on one hand, multiple agencies coming in. Second, the manner in which the investigation takes place. Now, you brought about the point of punishment. In a case which involves financial magnitude, which involves financial transactions in place, probably the manner of punishment need not be securing the presence by sending that person to jail. It could very well be trying to identify the so-called asset or trying to identify the so-called transaction which can be stopped or secured by way of preserving the actual money to ensure further dissipation does not take place. What do you see on the other hand? You will see every possible transaction that has taken place with that person, be it prior to the offense taking place, sale properties which belong to him from his ancestors, gifted to him by his father under a will, all being secured under the garb of an attachment. So you will see this person not being able to cope with any of the prosecutions properly, because he has to defend the same allegation wearing 5 different hats, and then being able to ask to prove as to how that particular transaction may be good for the purpose of one agency but will not be good for the other, because the tests and the law laid down for each of them is quite separate. So it to some extent will be a delay at the hands of the accused, but that delay is not his own doing, it's the doing of the system.
What do you say?
So I concede to the point that multiplicity of proceedings lead to delays, lead to costs, also have the potential of multiple verdicts. Now, hypothetically speaking, if somebody were to get acquitted in an SFIO complaint, midway a CBI predicate offense trial, instantly, if you have the same company, same time period, same transactions, it's an acquittal there without completion of trial. Or if vice versa, if it's a conviction, this only aids the prosecution here. And similarly then, because if you're convicted or acquitted in the predicate offense, the ED offense is just a rubber stamp to that extent. Having said that, I do see that as a problem, and I also do see that as a contributor to the burden on the judicial system in terms of large number of cases. Where I don't agree is that IBC does a great thing. It shows us, let's take an example of a hugely contested company, 𝗵𝗆 It was in losses, it was not being able to meet its debt, it was not being able to keep other financial commitments. The minute it goes into insolvency and gets taken over, suddenly there is a change that's happened. But that also goes to show you that during the course of insolvency proceedings, there are section 43, 45 and 66 applications that are filed, which are quasi-criminal in nature, especially in section 66, which is of fraudulent transactions. Simultaneously, there is an SFIO investigation, there are multiple bank fraud CBI matters. What does it go to show you? That somewhere the ex-management was not acting kosher, was not running the business with clean hands. There were related party transactions in the garb of siphoning of monies. The minute things are streamlined, the minute there is a fear that the system can take over in the interest of the economy, suddenly the company is running just fine.
I suppose at the end, the question comes down to this. What is the purpose of all these laws which relate to financial frauds? And finance and fraud in finance really mixes the criminal and the civil aspect of it, which is why we have this dichotomy. On the one hand is the desire, as Malak says, to ensure that a person who is prosecuted is not prosecuted or hounded to such an extent that they are unable, because they're actually physically in prison, to get the money for the banks. Or indeed that they're hounded by multiple agencies, that they're busy taking care of, even if they're not in jail, taking care of their cases rather than getting money. On the other hand, there is also a question of criminality. And living in a society where every business person feels that they are not above the law, that the law and the hand of the criminal law can reach into there and say, stop, just because you're powerful doesn't mean you can get away with it. And that is a desire for retribution that society has, an expectation that all the laws apply equally to everybody. And therefore, simply giving money shouldn't be a way to buy freedom for a person. But in the process of doing all this, we must keep the constitutional thread above us. You can take all actions, but the hand of the law is always above you. Individual liberty is not up for sale, neither is the national security or the economic stability of this country. We always have to find a balance.